I think what I'd encourage everyone to do is go check out the EDPB's opinion that gives some good examples on when legitimate interest can be a valid legal basis for using personal information to train some of these AI models. I think they talk about certain concepts as far as like what it would take to actually use quote unquote anonymous data, right? And you get sort of a definition there around, well, we can consider it anonymous if it's very unlikely to directly or indirectly identify individuals, as well as that querying the model itself or the tool. If I said, hey, tell me Jim Sturm's transactional behavior at Dunkin' last week, it's not going to go find Jim Sturm in that tool, so to speak, right? And so there's a lot of great guidance in there. And then the legitimate interest test, super familiar for those of us involved with GDPR, a lot of the same concepts. But I think the challenge, or at least one of the challenges I see that's sort of above and beyond nutritional privacy assessment or diligence here is, this balancing test of ensuring that the interests, fundamental rights, and freedom of data subjects aren't overly impeded compared to what the legitimate interest is of using this tool. And that requires a lot of conversations internally. And then some of these things we'll get into around like bias too, and how we audit and make sure that these models and these technologies aren't doing any potential harm.